pretty strongly about that.
The Supreme Court is set to hear arguments Tuesday on Proposition 8, the ballot initiative and amendment to California's Constitution recognizing only marriages between a man and a woman. The legal challenges to the law began almost immediately. The first from San Francisco City Attorney Dennis Herrera, who joins us now in studio. Good to see you.
Good to see you.
Okay, so let me get this straight. They have a ballot initiative. By some 600,000 votes, the people of California decide that they want to define marriage this way, and then an employee of the city, of the state, decides they want to fight this. How does that work?
Well, California is unique in that the initiative system empowers citizens to put things on the ballot, and it's actually not that difficult to do. But you can then sue to have something invalidated. We've done that a number of times over the years, and we sued first in state court to say that Prop 8 was unconstitutional. It continued a battle that we had already been involved in since 2004, which culminated in a California Supreme Court decision that said that California's discriminatory marriage laws were unconstitutional and then led to Proposition 8. Unfortunately, our challenge was met with defeat, but now we moved to the next venue, and that was the federal court, which is now going to culminate in a Supreme Court hearing tomorrow.
But you take the point, and this is a question I know has been put to you a number of times, but as an employee of the government, shouldn't you support the laws that the government, and in this case, the entire voting population of the state, decided on?
Well,
why overrule the people?
I'm an independently elected official, and I take an oath to uphold the Constitution. And if we were going to subject everything to the vagaries of the political process, we would not have any need for a Constitution or for an Equal Protection Clause. The United States Constitution and its Equal Protection Clause are there precisely to protect the rights of disfavored minorities from a majority in the political process who might want to continue discrimination against them. So that is precisely what a lawyer in my position should be doing, and what we've been doing for darn near 9 years now.
Let's talk about Tuesday's arguments. The thing about these Supreme Court cases is they get so complicated, but I wonder when you're there tomorrow what you'll be listening for to know which way the justices are leaning.
I am going to really be listening to see if they put the other side through the paces to have them, to draw them out with respect to the paucity of the record that they were able to develop in both the trial court and the Ninth Circuit Court of Appeals, where they produced virtually no evidence whatsoever to support why gay and lesbian individuals should be discriminated against. I have yet to hear a cogent, well thought out argument based in law and fact which would justify discriminating against gay and lesbian people.
Is that the legal question that needs to be answered tomorrow?
It's key, actually. It is absolutely key to the inquiry to look at the motivation behind what the Prop 8 proponents put forward, because once you grant a right, and once a right has been established, to then take it away, you have to have a fundamental inquiry as to the motivation in order to justify and say, does it serve a legitimate government purpose? Is it necessary to promote a compelling state interest? So those motivations are very, very important part of the inquiry.
Some folks have suggested, and I wonder how you respond to this, the idea that same-sex marriage is becoming more and more popular in the public, more and more politicians are supporting it or at least open to it. Is this pushing too far, too fast, to the detriment of the cause of same-sex marriage, creating a culture war that maybe doesn't need to exist?
No, I don't think that at all, and I think that is an argument that has been put out by our opponents because they had nothing else to hang their hat on with respect to the legal case. And let me give you an example. Back in 2004 in San Francisco, when we started issuing marriage licenses, people said the same thing. But it is precisely because of the 9-year battle that we have been involved in state courts in California and now in the federal court. I think it's precisely because of that the political debate has swung so quickly in our favor, and why you see such a rapid change in public opinion. It's because we put discrimination on trial, we put the faces of families and friends of individuals, and we told their stories, and I think that was vital to changing the public debate to the point where now you have 58% of Americans in a Washington Post poll last week that said that are in favor of marriage equality, and why in California 62% of Californians are in favor of marriage equality. I think it's precisely because we pushed the envelope that we furthered that political debate, and I think it's been helpful to the case as we've moved along.
Okay, thanks for stopping by, and we'll see you again tomorrow on a Google Hangout here at WashingtonPost.com. Wednesday. We have them every day. There are so many Google Hangouts, hard to keep track, but we'll see you on Wednesday.
All right, great, Brooke. Thanks for having me.